Hello, my name is Dipshikha Anand and I am from ICFA University, Dehradun, intern at DLSA, Deoghar. Today we will discuss about the Protection of Children from Sexual Offences Act 2012. The Protection of Children from Sexual Offences Act is an Indian law enacted to protect children from sexual abuse, exploitation and pornography. It was introduced to address the growing concerns regarding child sexual offences and provide a comprehensive legal framework to ensure the safety and well-being of children. If an attempt or commission of sexual assault, offense, harassment happens against a children, either male or female, under the age of 18 years, then such cases are filed under POCSO Act 2012. This law protects children from sexual assault, sexual harassment and use of pornography material for the purpose of sexual offense against children. Special courts have been established for the purpose of dealing with these offenses. Let us discuss some of the key points of this act. It covers all children below the age of 18 years. It is a gender-neutral act. It provides child-friendly process for recording, reporting and trial keeping. Best interest of child as top priority. It provides for establishment of special courts. The Act provides for the establishment of special courts for the speedy trial of offences under the Act. These courts aim to ensure a child-friendly environment during the trial process. Protection of identity of the child. The Act ensures the privacy of the child victim throughout the legal process. It prohibits the disclosure of the identity of the child in any media or public domain. Let us understand why was the necessity of this act. The Protection of Children from Sexual Offences Act was enacted in response to the growing concern of child sexual abuse and exploitation in India. Prior to the introduction of the act, there were various legal provisions across different laws that dealt with offences against children, but these laws were insufficient to effectively address the complex issue of child sexual abuse. There were no specific provisions or laws that dealt with the sexual abuse for the male child. For example, IPC 375 doesn't protect male victim or anyone from sexual act of penetration other than traditional penovaginal intercourse. The inadequacy of the Indian Penal Code as well as the lack of any strict laws for effectively addressing and countering crimes such as sexual exploitations and sexual abuse of children later prompted the creation of the POCSO Act. The need for a comprehensive law to protect children from sexual offences gained prominence following a series of high-profile cases of child abuse. These cases brought a national attention to the urgent need for stronger legal provisions and a dedicated framework to safeguard child from sexual exploitation. The Protection of Children from Sexual Offences Act was introduced to address this gap and provide a legal framework to protect children from sexual offences. The Act was formulated by the Indian government based on recommendations from various stakeholders including child rights activists, experts and organizations working in the field of child protection. The Act draws inspiration from international conventions and guidelines such as the United Nations Conventions on the Rights of the Child, UNCRC, which India is a signatory to. It incorporates principles and provisions from these international standards to ensure the protection, welfare and rights of child victims. This Act was passed by the Parliament of India in 2012 and came into effect on November 14, 2012. Its primary objective is to establish a legal framework that focuses on the best interests of the child, ensure their safety, and addresses the issue of child sexual abuse. Since its enactment, the POCSO Act has played a crucial role in raising awareness about child sexual abuse, facilitating reportings, and improving the legal response to such offences. It has provided a dedicated legal mechanism to investigate and punish offenders while prioritizing the well-being and protection of child victims throughout the legal process. Now, let us understand the various key objectives of this Act. First, protection of children. The primary objective of this Act is to protect children from sexual offences, ensuring their safety and promoting their well-being. Second, prevention of child sexual offences. The Act aims to prevent the occurrence of child sexual offences by establishing a legal framework. It seeks to create a deterrent effect through the provision of strict punishments and penalties for offenders, thus discouraging such crimes. Third, child-friendly procedures. The Act focuses on child-friendly procedures during the investigation, recording of statements, and trial processes. It aims to minimize the trauma and distress experienced by child victims during legal proceedings. Confidentiality and privacy. The Act ensures the privacy of child victims throughout the legal process. It prohibits the disclosure of the identity of the child in any media or public domain, protecting them from further harm and any kind of stigma. Speedy justice. The Act aims to ensure a swift and efficient legal process for cases involving child sexual offences by establishing special courts dedicated to hearing such cases with the objective of delivering speedy justice to the victim. Rehabilitation and support. The Act recognizes the importance of rehabilitation and support for child victims. It includes provisions for the physical, emotional, and social rehabilitation of child victims, ensuring their overall well-being and recovery. Awareness and education. The Act emphasizes the importance of creating awareness about child sexual abuse and the legal provisions available for protection. Offences under the POCSO Act: penetrative sexual assault, aggravated penetrative sexual assault, aggravated sexual assault, sexual harassment, use of child for pornographic purposes. Penetrative sexual assault: when a person inserts or penetrates his penis or any object or a part of the body or manipulates any part of the body of the child so as to cause penetration to any extent into the vagina, mouth, or anus of a child, or makes the child to do so with him or any other person, is said to commit penetrative sexual assault. Sexual assault: when a person with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child to do so without their consent, is said to commit sexual assault. Aggravated penetrative sexual assault: any police officer, teacher, hospital staff, or any other person under whose care and protection the child is or on whom the child trusts commits penetrative sexual assault with the child, or two or more people commits the act, then it is called as aggravated penetrative sexual assault. Aggravated sexual assault: any police officer, teacher, hospital staff, or any other person under whose care and protection the child is or on whom the child trusts commits sexual assault, or two or more people commit sexual assault using a weapon, then it is called as aggravated sexual assault. When does the offense become aggravated? The offense is aggravated when committed by a person in a position of trust or authority, such as police, army, security personnel, public servants, or family members, committed by person in management or staff of educational, medical, or religious institutions, committed by person in management of staff or jail, remand home, protection home, observation home, or any other place of custody or care and protection, committed by a person who has been previously convicted of having committed such an offence, either under this Act or any other Act. Also, the offence is aggravated when there is a gang assault, the offence causes grievous hurt, the offence causes physical or mental disability, the offence is committed taking advantage of child's mental or physical disability, the offence is committed more than once. The offence is aggravated also when the child is below 12 years of age, when offender is a relative of the child, when attempt is also made to murder the child, or when the offence is committed and child is made to strip or parade naked in public. Sexual harassment. Sexual harassment is any unwelcome sexual advance, request for sexual favors, or other verbal or physical conduct of a sexual nature. A person is said to commit sexual harassment upon a child when such person with sexual intent makes a child exhibit his body or any part of his body, shows any object to a child in any form of media for pornographic purposes, or repeatedly or constantly follows or watches or contacts a child either directly or through electronic for sexual favors. It can occur in any context, including the workplace, school, or even in public. Use of child for pornographic purposes. When a person uses a child for pornographic purposes by either representing the sexual organs of the child or using a child in real or stimulated sexual acts or representing a child indecently or obscenely in programs or advertisements on television or on internet shall be guilty of the offense of using a child for pornographic purposes. Punishment for offenses covered in the POCSO Act 2012. Penetrative sexual assault on a child of 16 to 18 years of age, mentioned under Section 4. The punishment is minimum imprisonment of 10 years, which may extend to imprisonment for life plus fine. Penetrative sexual assault on a child below 16 years of age, mentioned under Section 4. The punishment is minimum imprisonment of 20 years, which may extend to imprisonment for the remainder of natural life plus fine. Aggravated penetrative sexual assault, mentioned under Section 6. Minimum rigorous imprisonment of 20 years, which may extend to imprisonment for remainder of natural life plus fine or death. Sexual assault, mentioned under Section 8. Imprisonment of 3 to 5 years plus fine. Aggravated sexual assault, mentioned under Section 10. Imprisonment of 5 to 7 years plus fine. Sexual harassment, mentioned under Section 12. Imprisonment which can extend to 3 years plus a fine. Use of a child for pornography, mentioned under Section 14(1). First conviction, imprisonment extending up to 5 years. Second or further convictions, imprisonment extending up to 7 years plus fine. Use of a child for pornography while committing an offense under Section 3. This is mentioned under Section 14(2). Minimum imprisonment of 10 years extending up to imprisonment for life plus fine. Use of child for pornography while committing an offense under Section 5. This is mentioned under Section 14(3). Rigorous imprisonment for life plus fine. Use of a child for pornographic purpose while committing an offense under Section 7, mentioned under Section 14(4). 4. Imprisonment of 6 to 8 years plus fine. Use of a child for pornographic purposes while committing an offense under Section 9, mentioned under Section 14(5). Imprisonment of 8 to 10 years plus fine. Offences of storage of pornographic material involving a child for commercial purposes, mentioned under Section 15. Imprisonment extending up to 3 years or fine or both. Now let us see what are the process of recording the statement of child. Recording of statement of child by police. Child statement shall be recorded at the residence of child or at a place where the child is comfortable in presence of a woman officer not below the rank of sub-inspector. While recording the statement of child, police officer shall not wear any uniform. The police officer investigating the case shall make sure that the child at no point comes in contact with the accused. Under no circumstances the child shall be detained in police station in the night. Police officer shall ensure that child's identity is protected from public and media unless otherwise directed by the special court in the interest of the child. Recording of a statement of child by magistrate. Magistrate shall record the statement as spoken by the child. Additional provisions regarding statement to be recorded. Magistrate or police officer shall record the statement of the child in the presence of his or her father or mother or any person in whom the child has trust or confidence. Whenever necessary, the magistrate or the police officer may take the assistance of a translator or any interpreter. If the child has mental or physical disability, then the assistance of special educator or person familiar with the manner of communication of child may be taken to record the statement. Whenever possible, magistrate or police officer shall ensure that the statement of child is also recorded by audio-visual means. General principles of the POCSO Act. There are few principles which are to be followed while conduct of the trial under the POCSO Act. These are as follows. Right to life and survival. Every child has the right to life and survival and to be shielded from any form of hardship, abuse or negligence, including physical, psychological, mental and emotional abuse, and to a chance for harmonious development and a standard of living adequate for physical, mental, spiritual, moral and social growth. Right to be treated with dignity and compassion. Child victims should be treated in a caring and sensitive manner throughout the justice process, taking into account their personal situation and immediate needs, age, gender, disability, and level of maturity, and fully respecting their physical, mental, and moral integrity. Right to be protected from discrimination. The justice process and support services available to child victims and witnesses and their families should be sensitive to the child's age, wishes, understanding, gender, sexual orientation, ethnic, cultural, religious, linguistic, and social background of the child, including health, abilities, and capacities. Right to special preventive measures. Child being immature in their growing stage should be well treated so that they become capable of preventing abuses against them, thereby differentiating between what is right and what is wrong. Right to be informed. A child should be informed of the legal procedures that are being carried out for the conviction of the accused. Right to be heard and to express views and concerns. Every child has the right to be heard in respect of matters affecting him or her. The child has a right to participate at all levels, being informed, expressing an informed view, having that view taken into account and being the main or joint decision maker. Right to privacy. The child privacy and identity must be protected at all stages of the pre-trial and trial process. Last, right to safety. Where the safety of a child victim may be at risk, appropriate measures should be taken to require the reporting of those safety risks to appropriate authorities and to protect the child from such risk before, during, and after the trial process.
So, I, Aparna Akansha, would be further explaining you about the medical examination under POCSO Act, the need for it, trial of the offences under POCSO Act, major judicial pronouncement regarding it, and the way forward. So, Section 27 of the Protection of Children from Sexual Offences Act 2012 talks about the medical examination of a child. It has major three provisions regarding it. The first one is that the medical examination of a child in respect of whom any offence has been committed under this Act shall, notwithstanding that a first information report or a complaint has not been registered for the offence under this Act, be conducted in accordance with Section 164A of the Code of Criminal Procedure 1973. The second provision talks about the victim being a girl child. The medical examination of a girl child shall be conducted by a women doctor. The medical examination of a victim child should be conducted in the presence of the parent of a child or any other person in whom the child has trust. Now we will deal with why we require medical examination. There are basic points regarding the need for the medical examination. The first one is that medical examination helps in providing first aid to the victim. It also plays a major role in determination of the age of the victim, whether he or she is minor or a major. It also tells us about the general health condition of the victim, the physical and the mental health disability or trauma faced by a victim. It also plays an important role about the mark to display mark of any violence or injury resistance upon the victim. Trial of offences under POCSO Act. Section 33 to 38 makes provision regarding the trial of offences under this Act. Section 33, which talks about deposition of victims, specifies that special courts can take cognizance of the offence without the accused being committed to the trial. Section 36 mentions about that the collection of evidence should not be in the presence of the accused. In the famous case of Vasudev versus the state of Karnataka, this has been upheld. The POCSO Act also talks about the time limit within which the disposal of case should occur. Section 35 of this Act stipulates the following timeline. For recording the evidence of a child, 30 days from the date of taking cognizance of the offence, and for completing the trial, 1 year from the date of taking of the cognizance. Jurisdiction of the POCSO Act. Section 28 of this Act lays down the provision regarding a designation of a special court to try the disputes that fall under the category of POCSO Act. Section 33 gives the power of a court of session to be a special court under this Act. It also says that special courts have jurisdiction to try offences under Section 67B of the Information Technology Act 2000. Further, Section 42A of the Act says that in case any inconsistency, the provisions of the POCSO Act would override the provisions of any other law. Some of the significant judicial pronouncements regarding the Act is Jarnail Singh versus State of Haryana, State of Karnataka versus Shivana, Lebanese versus State of Maharashtra. In the Jarnail Singh versus State of Haryana, the Supreme Court of India observed that the procedure which is used to determine the age of a child in conflict with law, as per the Juvenile Justice, Care and Protection of Children Rules 2007, can be followed in cases falling under the POCSO Act 2012 as well. In the state of Karnataka versus Shivana case, it was observed that the POCSO Act 2012 does not require recording of every statement made under Section 164 of CRPC. The statement of the victim under Sections 354, 354A, 354B, 354C, 354D, 376 clause 1, 376 clause 2, 376A, 376B, 376C, 376D, 376E or 509 of the IPC should be recorded by a judicial magistrate according to the sections of 164 5A of the Criminal Law Amendment Act 2013. In the Lebanese versus State of Maharashtra case, the primary issue dealt by the High Court was whether holding hands of a child and taking out private parts in front of her would fall under the definition of sexual assault under Section 7 of the POCSO Act or not. The Nagpur bench adjudicated that holding a minor's hand and opening zip of pants will not come under the purview of sexual assault. Rather, it falls under the category of sexual harassment. The Juvenile Justice Act and the POCSO Act has a co-relationship between them. These are the following things that tell us that there is a relationship between these two acts. The child victims under the POCSO Act can be also children in the need of care and protection that falls under the purview of the JJ Act. The support person to the child victim to be provided by the Child Welfare Committee is comes under the purview of the Juvenile Justice Act. The Juvenile Justice Board should adhere to the child-friendly procedures prescribed under the POCSO Act 2012. The Juvenile Justice Board should take measures for the free legal representation of the child victim. Age determination. Section 94 of the JJ Act talks about the provision of age determination of minors which is applicable in POCSO Act. The POCSO Act has some of the issues with it. Some of the issues that are in this act are lapses in investigation, low representation of women in the police force, age determination being an important problem, delays in filing of charges, low representation of women in police force. The Act provides for recording of the statement of the affected child by a women sub-inspector at the child's residence or place of choice. But it is practically impossible to comply with the provisions when the number of women in the police force is just 10%, and many police stations do not have women staff. Lapses in investigation. Though there is a provision to record statement using audio-video means, there are still reports of lapses in investigation and preservation of crime scenes in some cases. Issues of age determination. Though age determination of juvenile is guided by Juvenile Justice Act, no such provision exists under POCSO Act for juvenile victims. The investigation officers continue to rely on the date of birth recorded in the school admission or withdrawal register. In most cases, parents are not able to defend the age in the court. The age estimation based on medical opinion is generally so wide in scope that In most cases, minors are proved to be major. Delays in filing of charges. According to the POCSO Act, the investigation under this Act shall be completed within a period of 1 month from the date of commission of the offence or from the date of reporting of the offence. However, in practice, the investigation often takes longer than 1 month due to various reasons like inadequate resources, delays in obtaining forensic evidence, or the complexity of the case. This results in delays in filing of charges and commencement of trial, which affects the speed, effectiveness of justice for victim and gives mental and physical trauma to the victim. In the previous slides, we have come across the background, the objectives, and the various provisions of the POCSO Act. We have also come across about the medical examination, the issues that are prevalent in this Act. Now, we will talk about what is the way forward in this Act. What are the measures that government can take on their part to ensure that the provisions of this act are aptly followed? The government should provide for adequate resources such as funding and personal personal training to the investigation agencies in handling POCSO cases. This will help to ensure that the investigations are conducted in a timely and efficient manner. Investigation officers should be provided with proper training on handling of POCSO cases, training on the proper technique for collecting and preserving evidences, interviewing child victims and witnesses, and the legal requirements of the POCSO Act. The medical examination of the child victim should be conducted as soon as possible after the abuse in order to establish recent intercourse. Public awareness is one of the major uh, actions that can be taken in this field. Raising public awareness about the POCSO Act, the importance of reporting child sexual abuse, and the rights of child victim can help to increase the reporting of cases and improve the investigation process by reducing the social stigma attached to this. We can further conclude by saying children are the future of our society. The investigation agencies, police officers, judicial officers, and each and every authority concerned to it should take adequate measures to comply with the provisions of the POCSO Act to preserve the blooming birds of our society. Thank you.